now in session, the Honorable Judge Richardson. You may be seated.
All right, we ready for our jury?
Yes, sir. Yes, sir.
All right, Mr. Mullins, go get our jury. Counsel, approach real quick for a minute. Is there something? Oh, I'm sorry. You can be seated. Ladies and gentlemen, welcome back. Is everybody able to follow my instructions and admonitions over our break?
Yes.
Yes, sir.
All right. Mr. Rithkers, call your next witness.
Dr. Levaughn, Your Honor.
Raise your right hand for me. You solemnly swear or affirm that the testimony you will give in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
You may proceed.
Dr. Levaughn, could you please tell the ladies and gentlemen of the jury your full name
Mark Mitchell Levaughn,
and your professional address, please?
215 Allen Stewart Drive, Pearl, Mississippi.
And are you a medical doctor?
Yes, sir.
What's the nature of your specialty?
Forensic pathology.
Could you give us a description of your educational background?
I graduated from high school and college in Steubenville, Ohio. I graduated from University of Tennessee Medical School in Memphis, Tennessee. After that, I completed a four-year pathology residency training program at West Virginia University. And following that, I've completed a forensic pathology fellowship training program at the University of Tennessee in Memphis. And I'm board certified in anatomic and forensic pathology.
Are you currently licensed to practice medicine in any states?
Yes, sir. Mississippi and I believe my Indiana license is still current.
How long have you been licensed?
Totally in several different states, approximately 32 years.
You mentioned that you're board certified. What does that mean?
Every medical specialty has a board certification, and basically it is a test of your comprehension of your training in that field. In pathology, it was several parts. It was a written test. You looked at microscope slides, looked at photographs, and once you attain a passing score of the board exam, you are deemed board eligible in your field of medicine. And mine is forensic and anatomic and forensic pathology.
Dr. Levaughn, do you teach? Do you teach?
I do. I teach where I'm currently at. I teach coroners, medical and dental students for the University of Mississippi. I present at national, international meetings, give presentations.
Doctor, have you testified previously in any capacity as an expert?
Yes, sir, many times.
Approximately how many times have you testified as an expert?
Total over the years, I think it'd be in the thousands, several thousand times.
And what type of cases did you testify in?
In my field of medicine, the majority of the cases are homicide cases.
And in the cases that you've been an expert in and that you testified in, did you testify on behalf of the government, the prosecution?
The majority of cases are for the prosecution, yes.
And when we say a majority, what percentage of these thousands of cases that you testified in, what percentage was for the government?
Probably 99% of the time.
Have you ever testified in a case where somebody's been accused of a crime?
I have occasionally in my career, yes.
And so that would be the other 1%?
Yes, sir.
Dr. Levaughn, could you just briefly tell the jury how it is that I came upon you and have you here today?
An anthropologist employed in my office, I believe the sequence was you contacted him. He wanted to do an examination, asked me permission to do that in the office, and I said that was fine. And during that examination, he consulted with me, and I believe in a phone conversation with that anthropologist, you and I spoke.
Approximately how many autopsies have you performed in the course of your career?
Probably somewhere between 12 and 13,000.
How many autopsies did you do last year?
Last year it was about 715.
Could you please describe to the ladies and gentlemen of the jury what you do as the chief medical examiner for the entire state of Mississippi?
I run the medical examiner's office as a doctor's office, where we examine patients, we admit patients, we examine patients, and we discharge patients. So, and the daily functions of the office, I supervise all the employees, one other forensic pathologist, one office manager, and 8 autopsy technicians. I assist with the writing of the budget, writing policies and procedures. I'm in charge of hiring and firing employees. I do training for the coroners. I testify in court frequently. And I do autopsies just about every single day.
I noticed you said that you treat your patients, and I take it those patients are all dead, correct?
That's correct.
Do you have any experience with?
I hope I didn't say treat patients.
That's
Okay.
I misstated.
We admit and examine and discharge.
Did some of your past autopsies include skeleton remains?
Yes, sir, many times.
And are you experienced with remains that have been burned?
Absolutely.
Now, at my request, Dr. Levaughn, you're here today to give us your opinions based upon your examination of the remains of Annabelle Richardson and other materials. Is that correct?
Yes, sir, that's correct.
And before we get into the basis of your opinion, based on your education, experience, and background, do you have an opinion to a reasonable degree of medical certainty as to the cause and manner of death of Annabelle Richardson?
Yes, sir, I do.
And could you tell the ladies and gentlemen of the jury what that opinion is?
In my opinion, the cause of death of Annabelle is undetermined. And in my opinion, the manner of death of Annabelle is undetermined.
Now approach. Doctor, I'm going to hand you what's been marked as Defendant's Exhibit DD. And is that the report that, is that your report as a result of this examination?
Yes, sir, that's correct.
And attached to that report is your CV, is that correct?
That's correct, yes, sir.
Okay. Now, if you would, could you read that portion of the report, the bottom part? Just learning how to use this, so. This portion right here, could you read that for the ladies and gentlemen of the jury, because this is your opinion?
Yes, sir. After review of the above documentation and examination of the skeletal remains, it is my opinion that, 1, the skeletal remains showed no identifiable evidence of thermal injury. 2, the skeletal remains showed no identifiable evidence of violent traumatic injury. Number 3, due to the advanced state of decomposition and lack of soft tissue for examination, there is absolutely no identifiable evidence of live birth. Number 4, because of the lack of identifiable violent injury and the lack of evidence of live birth, it is incorrect to state that this child died of homicidal violence of undetermined etiology.
And when you say it is incorrect to state that this child died of homicidal violence, you're referring to what Dr. Allen testified to here a few days ago, is that correct?
Referring to the opinion in her report.
Now, can you please tell the ladies and gentlemen of the jury the basis of your opinion?
The major basis of my opinion is the actual examination of the remains, and it was also based on examination of the documentation that's listed on the report. The reason my opinion is the cause of death is undetermined is because there is, in my opinion, after examination of the remains, there is no identifiable evidence of any cause of death, let alone any traumatic cause of death. There's no evidence of the child was alive at birth. And the manner of death, in my opinion, is undetermined because there's no evidence of, and mainly it's based on the fact there's no other available portion of the child to examine. We were only able to examine bones. So the child, it's not possible to say that the child died of a natural death. It's not possible to say that the child committed suicide. It's not possible to say that the child died of an accident. In my opinion, it's not possible to say that the child died of the manner of death is homicide. So of the 5 manners of death, if you cannot assign a manner of death, one of the 4 I just mentioned, then the manner of death, in my opinion, must be listed as undetermined. And undetermined doesn't mean that anything was done incorrectly. It just means that there isn't enough information to choose one of the other 4 manners.
Is there evidence that any evidence that the child was born alive?
In my opinion, no.
Dr. Levaughn, you also, as part of your examination, you were able to review the interrogation tapes and of Skylar Richardson, is that correct? As part of everything that you looked at. Was that one of the things that you looked at?
There were two videos that I viewed.
Of her interrogation?
Yes, sir, that's correct.
In that second interview, based on your medical knowledge, is it possible to light a baby on fire by putting a lighter to its foot?
Absolutely not.
And doctor, you're also aware that there was no accelerant found at the gravesite?
I am aware of that. That's correct, yes.
And you had the opportunity subsequent to your report to review, and I'm a defendant's exhibit QQQQ.
Nature of the objection, you may. Mr. Rickers, you may continue.
May I approach?
You may.
You a document which is purportedly from the state's fire marshal. Have you seen that document before?
I have, yes, sir.
Yeah. And I may have 1 second. Now, assuming that what I just handed to you, and you read that it says no ignitable liquid was detected in exhibits 1, 2, and 3, which were soil samples and a little piece of cloth, would that in any way affect your opinion that you're giving here today?
No.
Dr. Levaughn, in reviewing those interrogation tapes, the events described by Skylar Richardson in those interrogations that you reviewed is what you pathologists and maybe other docs would call a spontaneous birth in a toilet?
In my opinion, that's correct, yes, sir.
And do you have any idea how often that happens when it comes to you?
I'm not sure I understand the question.
I'll rephrase it. Have you had any cases where you've had a spontaneous birth in a toilet?
Yes.
And doctor, is it critical to an investigation where a baby is reported to have come out of its mother into a toilet to know the obstetric history?
In my opinion, yes.
And why is that?
Well, if we're examining the child, the reason we're examining the child is to determine cause and manner of death. And it's useful to have in any patient that we examine in a postmortem examination, it's good to have any medical history that's available. So any prior medical history of other births, complications, that's all useful in determining cause and manner of death of a patient.
What about, is it important to know the mother's level of maternal ignorance? Is that important to an investigation?
I think that's important, yes.
And it's important, why would you say it's important?
Well, it'd be important to understand what the person may have had knowledge of or been experiencing, and it'd be important to, in the investigation, to prevent any improper conclusions.
Improper conclusions from placing too much of an emphasis on the mother's statements in the case history?
That's possible, yes.
Dr. Levaughn, how important would it be in this particular case to have an obstetrician consult?
Did you ask in this particular case or
In this particular case.
In this particular case, in any particular case, it would be useful to have information of another expert.
No further questions, Your Honor.
Mr. Knippen, you may inquire.
Thank you. Good afternoon, sir.
Good afternoon.
So you note that there is a lack of identifiable violent injury, is that correct?
In my opinion, that's correct.
But you would also agree with me that you would not expect to see violent injury just to the bones of this child if the child was suffocated. Is that fair to say?
There would not be any evidence of suffocation, no.
Okay. And there would not be any evidence just from examining the bones of whether this child may have been drowned in the water. Is that fair to say?
That's correct.
And you would agree with me that you can have burning to just the skin or the tissues without it reaching all the way down to the bones. Is that correct?
That's possible, yes.
And due to the advanced state of decomposition of the body of the child and the lack of soft tissue, really all that we were left with were just the bones themselves. Is that correct?
That's correct.
And the fact of the matter is that by the defendant burying this child in her yard for 2 months without telling anyone, she deprived you and anyone else of being able to medically assess what happened to this child. Is that fair?
That certainly diminished the ability to examine the entire body, yes.
Nothing further, Your Honor.
Redirect?
Let me have a second. We have no further questions of this witness, Your Honor.
Thank you, sir. You can step down.
Thank you, Your Honor.
All right, ladies and gentlemen, we're going to take another break. You know, sometimes a trial is like a 5-year-old's birthday party. The longer it goes on, the tougher it is to control all the moving parts. So I apologize that we are taking frequent breaks, but we have some stuff that we have to get set up for our next witness. This will be a relatively short break. I anticipate no longer than 5 or 10 minutes. Mr. Mullins, you can take the jury out. You can be seated. We're on the record outside the presence of the jury. All right, so your witness needs an HDMI cable?
He needs something to be able to connect to the system, Judge.
Okay, so is he going to connect to your the law laptop
We can do that.
connection?
We can do that.
Will that work, reach from there to there?
So I gotta go to his computer, he's ready to do it.
Yeah, but he wants to testify from there. He can't testify from there. That won't work.
We can take that computer over there if this reaches. Judge, he's gonna be our last witness, and he is leaving his place of employment that he couldn't change at 2 o'clock, so we'll be here at 2:20.
We can run it, we can run it from, we can run it from there. I think it fits.
Looks like it makes it.
Does it plug in? Oh, right here.
Yeah.
Okay, yeah.
It'd just be easier to do from there. Doesn't matter which table you do.
Yeah, I understand why they would want to do it from the defense side, so that makes sense.
Whichever.
Okay, all right. Thank you, Mr. Larson. So we will have the witness here at 2:20?
He says 2:20, he's 20 minutes door to door, and he couldn't change something, he's leaving at 2 o'clock.
Okay, go get our jury, Mr. Mullins.
We want to test it just real quick to make sure.
We're gonna go get the jury, the jury's gonna come in, and then we're gonna send the jury back out, and then we'll test it. You may be seated. Ladies and gentlemen, welcome back. We have a bit of a scheduling difficulty that is gonna take us probably about an hour to resolve. So we are gonna take a break until about 2:30. So we are gonna keep you here in this area. Mr. Mullins we can get you out on the patio area. But we're trying to work through this scheduling issue as we go now. We anticipate that our evidence is going to finish today, and that we are going to do closing arguments and instructions of law tomorrow morning, and that you will probably begin deliberating tomorrow. I don't know that for 100% sure, and don't hold it against me if the calendar changes, but we are doing the best that we can. Just try to give you this information so that you can sort of plan ahead with the folks at home and so forth. So we're going to take about a 45-minute break, and maybe closer to an hour, and we will see everybody back here then. Remember what I have told you about this previously. Don't start thinking about how you should decide the case, or begin to talk amongst yourselves. I know the farther along that we get in the case, the more of a temptation it is to think to yourself that you know enough about the case to start thinking about how it should be decided. You don't. We haven't heard all the witnesses. You haven't heard the closing arguments. Most importantly, you haven't heard my instructions of law. There will be plenty of time for you to think about how this case should be decided later. Don't do any research or read about any of this on your phones until we come back, and I'll see you in about 45 minutes to an hour. Mr. Mullins, you can take the jury out. You may be seated. We are on the record outside the presence of the jury. Mr. Rickers, you wanted to make a proffer?
I do, Your Honor. I would like to proffer for the record that we had the State Fire Marshal's report, which obviously was not allowed to put into evidence, that says that there was no accelerant used at the scene, and I would like to proffer the document for the record.
Okay, Mr. Knippen, to state a position on that?
So proffering it for the record, or?
Well, I mean, they're proffering it. Is there any argument that you want to make for the purposes of the appellate record?
Your Honor, the state's objection to it was that it was not properly authenticated. It was my understanding from the witness, he said that he did not rely on that document in formulating his opinion. In fact, even when he was asked the question afterwards, he said it wouldn't have changed his opinion. And so if the defense wanted to have that document properly put before the jury, I believe they could have called the individual that prepared that report.
If I may add,
Go ahead.
if I may respond, this document was provided to us by the prosecution, and I think it's a little bit disingenuous to claim that this is not properly authenticated when they themselves got it from the State Fire Marshal and gave it to us. And we were going to try to get it through the lead detective, Detective Carter, but she did not testify. So that's it.
Was it, I don't understand, was it part of the investigation?
Yes.
The report, was it part of the investigation? I mean, how would that even help? Detective Carter can't authenticate it, or can she?
And that's the state's position. I don't believe that Detective Carter would authenticate it. Detective Carter didn't prepare that report. Molly Jordan prepared that report.
Okay. Anything else? I mean, make your arguments for the record. I mean, I've already decided that I am not going to permit the expert to testify about it, nor am I going to allow it into evidence. So if you want to tell the folks in Middletown anything about this, assuming that the case gets that far, now is a good time. All right, so any reason not to go ahead and talk about exhibits while we have some downtime? Thanks, Justin. All right, so let's first clarify. Are we going to have an on-the-record discussion about it or an off-the-record discussion? If we're going to have an on-the-record discussion, let's talk in our normal voices. Yesterday, or when we did the defense, we sort of had a quasi-on-the-record discussion. I mean, if it's going to be on the record, just talk so that Debbie can hear you. Sure. All right. So this, we have one other exhibit, so this is subject to the admission, the testimony of the other witness. I mean, I'm not locking anybody into anything here, but at least as we know now, we're going to go through the exhibits and what the objections are to those exhibits. Okay. All right, so What are our exhibits?
Defendant A is just the cover page of the interrogation, unless we want to do a joint exhibit on the interrogation.
I mean, they're already in through the state exhibits.
Okay, well, we just, they're ours.
But you're talking about the transcript?
Oh, the transcript's not, this is in the, it's just the cover page, so we'll take that out.
So no A and no B?
Well, there's no transcript in it, Judge. Can we just use this as the disc or interrogation that we wanted them to be able to see?
Okay, so we're entering the same,
Yeah, I mean, it's just a cover page of the interrogation, no transcript behind.
okay. Objection, no objection to anything, right? It's the same thing?
Correct.
But, I'm sorry, you're gonna have the disc in there, or you're gonna have just the
They
first
can
page?
use your disc, we just don't want the jury to believe that we didn't want the interrogation to go back.
Oh, okay.
So they can use your disc if you want to provide one as well.
No, you don't have, I was just trying to make sure that I understood.
Okay.
All right, so A would be the same as, what's the state's exhibit for, so it would be 119, so A equals 119, right?
I don't have our list, Judge.
And 121, I believe, is the
119 and 121, Your Honor.
Okay. I'll take that as you are correct, sir.
The disc that you're gonna provide, because there's been several discs. that
I'm not
we've
gonna
had.
provide.
Oh, there's not gonna, okay, sorry.
So we'll just put that's the same as 119, same as 121, okay.
D, Your Honor, is photograph of Carlisle Police Station.
Did we skip over C? What happened to C?
Oh, sorry, C, yes. A picture of Carlisle Police Station.
No objection.
D, this was not testified to my knowledge, this particular picture.
So D is out?
D is out. I believe E as well. E is out, Your Honor.
Okay.
F was testified to inside the interrogation room.
No objection to F, right?
No, Your Honor.
G?
G, same thing, inside interrogation room.
No objection
No
to G?
objection.
H,
No objection to H?
I believe is out, Your Honor.
Oh, okay.
Next one we get. No. Your Honor, L is a photograph of Skylar's bedroom.
All right, so I, J, K are all out?
Correct. J may be with. J might be with our expert, our witness who's coming in.
Okay.
But
So I for sure,
H, I, and K are all for sure out.
okay. No objection to L through O, right?
We guys just stipulate to J, and I won't have to ask him about it. It's just an aerial. I think it might even be from you on Google aerial image.
No, that's not no.
Okay. Your Honor, we'll just admit J right now.
Okay. So then no objection to L through O, right?
But those are, no, those are
Veteran?
yours.
Those are ours. L through O are ours.
Those are the ones that are.
One of them.
Okay. No objection to those, Your Honor.
So L through O are in.
Charlie, are these the ones that are out?
Those are out, yes. Okay, so L, M, N, and O are in, Your Honor.
Yes.
Is that right?
Yes.
P and Q will be testified to by this next witness. It's a photograph of a toilet with a measuring tape. He took them personally. Do you want?
I think we
Any objection to P and Q?
I don't believe there will be, Judge, as long as there's testimony about it.
All right.
R was testified to, Carlisle Police Station front door.
No objection.
S was not. T, Carlisle High School records. I thought, did we agree to records coming in? Skylar's? Dad, do you want to be talking
I don't think we were agreeing that they come in.
There's a
You are
lot of-
agreeing or not
No, I
agreeing?
think that we're not
There's a
agreeing.
lot of stuff in there that was never testified to.
My note was that the stipulation was to medical records, but
If I may, the expert they reviewed those, Bassman being one of them. I remember, I think Dr. White also testified that he had reviewed them by mistake.
I guess the state's position, Judge, just because an expert reviewed something doesn't mean that 94 pages of the document come in.
I think I would agree with that.
Is it just Bassman's report or is everything behind it coming in? I'm taking S out.
What is that?
S are the school record.
That's T, isn't it?
T
Oh, sorry.
is not
T,
coming
yeah,
in?
that's right.
Did you say it's not coming in?
I was just, are you offering T?
We offered T, yes.
All right, so the objection to T will be sustained, so T will be excluded.
U, Your Honor, is,
All right, U through Z all come in by way of stipulation, right?
yeah, this looks like medical record. U is a nutrition record. V is Cincinnati Center for Wellbeing, also medical Terry Roll. W,
Judge, ours, and again, I'm sorry for any misunderstanding, our agreement to the stipulation of the medical records it was our understanding it was the Hilltop OBGYN records.
With regards to the other records, I believe that the discussion was we would stipulate that they were authentic, but not to their admissibility, that they are what they purport to be, but not that they would be admissible.
That's a correct, it's a correct statement.
Okay.
so do you want to offer them or not?
Which, tell me what records they are.
U is done. V is roll. W is children's. Take it out.
Take it.
Y was. All right, well, I've done that.
We stipulated.
All right, so U, V, W, and X are not being offered?
Correct.
That's correct, Your Honor.
Y comes in by stipulation, right?
Correct.
So does Z, Your Honor.
Z comes in by stipulation.
Oh,
AA, do we have the objections to the redacted version that is proposed by the court?
I've not had a chance to review that. Can we come back to that, Judge?
Okay.
I'm sorry, I apologize. I just haven't had an opportunity to review.
All right, so we'll circle back to AA and BB and also EE. CC is not being offered, right?
So AA, Your Honor, is what?
That's AA, BB are the reports of Dr. White, EE is the expert report of Hirsch.
All right. CC is Sims.
CC is Sims, which is not being offered.
Correct.
DD, any objection to DD?
No, Your Honor.
DD will be admitted. We'll talk about EE when we talk about the other ones. Do not believe. I'm looking at my notes on the Bassman report. Is there any objection to the Bassman report?
Do you remember? Was there anything?
All right, let's talk about that when we talk about all the rest of them.
Okay.
So GG through KK, are those being offered?
Your Honor, 1 minute. Was this one? We should. So, Your Honor, we are not offering GG, HH, II, JJ, KK. I'm gonna take those out. Sorry, KK is,
So GG through KK are not being offered?
that's correct.
All right. LL?
LL. Susan Allen and Murray.
Yeah.
LL is being offered, Your Honor.
Any objection to LL?
Yes, Your Honor, I believe only a very small portion of LL was ever testified to or displayed to the jury.
All right, LL will be admitted over objection.
These are emails with Dr. Murray and Steve Kniffin.
And again,
Objections to MM and NN?
yes, Your Honor. With respect to MM, neither myself nor Ms. Murray testified, and so I don't believe, and again, that only a small portion was shown to the jury, so I don't think it's appropriate for the entire email exchange to go back.
All right, we'll exclude MM and NN.
And Your Honor, is between Allen and Murray.
Yes, I will exclude, oh, wait. Allen is Brown, right?
Yes, sorry.
Okay. All right, no, I will admit N,
And
so only MM will be excluded.
okay, that's out. OO,
No objection to all the OOs, right?
someone not testified to, Your Honor, I believe.
Can you show me what?
Yeah.
Is that the, no, Judge, we did object to all of those.
Well, I mean, I'm sorry, subject to previous objections.
Yes.
So 1, 2, through 10. Through 10 were testified. Do you want to see these?
No, as long as the judge notes
I
that.
have testimony as to 1 through 21, and then 25, 26.
Don't believe, Your Honor, 11 or 12 were testified to.
So 11 and 12 are not being offered?
No. 13, sorry, what did you have it to, Your Honor?
I have through 21.
We are pulling 20 and 21, Your Honor.
Okay, so 1 through 10, and then 13 through 19 will be admitted over the state's objection.
Yes. 22, do we have that, Your Honor?
I do not have a note about 22, 23, 24. I do have a note about 25. That was the side-by-side truss.
4, so 22 through 24 are in?
I don't have a note that they were talked about.
Oh, yeah,
I mean, if I
22
looked
is-
at them, I might know, but I
I
don't.
remember seeing 22.
22 is,
Yeah, okay, 22 is in.
23 is.
I remember that one.
Scott, and this is
Okay.
addressed.
All right, so 22, 23, and 24 will be admitted over the state's objection.
And I don't know that it matters, Your Honor. The state would not object to 24, which is a picture of her in her prom dress, but we would object to the other two.
All right,
25, Your Honor, is a side-by-side.
that'll be admitted.
26 is a beach picture in Florida.
No objection.
27 was not testified to, I don't believe. 28 was testified to, Your Honor's picture of Skylar in her prom dress and her boyfriend.
No objection.
29 was testified to, senior, for senior year.
Same objection as before, Your Honor.
30, I don't believe was testified to, is that right? 31 was testified to, it's child watch group.
No
All right,
objection.
so 28, 29, and 31 will be admitted over the state's objection.
PP, Your Honor, was testified to, it's a picture of Skylar at work with a baby.
Same objection, Your Honor.
All right, admitted over the state's objection.
QQ will be this next witness, and then it will be more full instructions, it's the virtual tour.
Okay.
RR is an actual exhibit. We have a photograph in here. It's the tape measure that Dr. Andrew and Dr. Boyce have to use in their everyday practice.
No objection.
SS, no, not testified to.
Yeah.
It might be there. You guys have any objection to SS? It's your photograph. I know we talk a lot about it.
I'm pretty sure we used it.
That's fine. No objection.
No objection. TT, same thing. for
No
veteran.
objection.
UU, also for veteran.
No objection.
BBM.
No objection.
Was WW testified to?
All right, so RR through VV will be admitted without objection.
WW is out, Your Honor.
WW's out.
It's out. XX was not testified
You see?
to. It's a picture of a notebook. YY
All right, I'm sorry, why?
YY is no objection, Your Honor. Right?
Which one?
That was photographed.
Yes,
All
no
right.
objection.
ZZ's out. Triple A, Steve is photographed.
No, no objection.
Objection. Judge, you want BB, triple B and this? No.
So you say AA is,
AA, no objection, Your Honor.
Triple A, isn't it?
Triple A.
yeah, 3,
Sorry.
okay.
Do you want to pull BBB?
So-
Triple B is pulled, Your Honor.
Okay.
That is triple C. These are all yours, I say.
Cool.
Triple C, we're not admitting, Your Honor. D, keep it. Triple D, Your Honor. Just whatever.
No objection.
Triple D,
No objection?
Triple E, Deb, this is the brush.
Pull it.
Triple E is not being offered, Your Honor. Same.
Pull it.
Just flip through these. Your Honor, triple F, triple G, and triple H we are not offering. Triple I. No objection. Triple J, no objection. That's a tree line, yeah.
Okay, no objection.
F. Triple K.
Yeah.
Okay, triple K. Just here, before they had the long bone. You want that?
Yeah.
Triple L is not being offered, Your Honor.
Is triple K being offered?
Yes.
And there was no objection.
Okay. L's not being offered, triple L?
Correct.
Nobody testified. Yeah.
Leave it. Your Honor, MMM through quadruple B is not being offered.
Okay. Takes us to 4C, the photo of the mattress.
Yes, 4C is being offered.
No objection?
No, Your Honor.
4D, Jack. It's just a close-up of the triple.
Yep.
I think we would object just because I don't think there was any testimony about that specific photograph. I know the other one we had testimony about.
I thought there was a zoom in when he crossed the surface.
I do not have any note about 4D being talked about.
No, no, no.
Oh, it might be the state's exhibit of this, is what might have been talked about. It's the knife on, the butter knife on the bed close-up.
We have two. There.
We can pull it.
All right, so 4D is not being offered?
Yeah, that's fine.
Objection to 4E?
This was what you testified to. That's the one you testified to. That's the big thing.
No objection.
So we're pulling. No F, Your Honor. That's 4G is not being offered. ACOG bulletin, Your Honor, is quadruple K.
Wait, is 4, let's back up a little bit. 4H?
I didn't even have 4H, Your Honor. I don't see it.
This is 4I and 4J were the deeds, right?
Yes.
4I and 4J.
Yes. Those were the burial plots.
Those have already been excluded.
Oh, yes.
I don't know what 4H is.
I think
haven't-
originally there
Somebody
was-
talked about it.
Yeah, it
4H.
was, 4H was part of the ACOG bulletin, and then later we identified the whole bulletin as 4K.
4K.
Okay, so there is no 4H?
No.
There is a 4K there.
Yes.
Objection to 4K?
Yes, Your Honor, and correct me if I'm wrong, I don't believe we were provided that in discovery, and I don't believe the entire contents of the article was displayed.
Let me see 4K. Oh, okay, I remember this. Yeah, 4K will not be admitted. With 4L and 4M, the calendars? Or
Yes.
no, this is where things get a little foggy for me, because my notes are terrible on.
I'm sorry.
Those were just for.
Yeah, we don't need to submit.
Okay.
The
So
only
what's
thing
left in
is,
exhibit
this is the
one?
newest version that we're marking as 4P, so.
Quadruple P, Your Honor, this will be instructions. They've changed a little bit because there's a Google update on how to operate the inside home tour. And they're printed, for the record, the printed instructions that will guide a user on a laptop to walk through the virtual tour on a laptop.
Fine. So our witness is going to talk about these.
Yes.
No objection to QQ? I'm sorry, to 4P?
No, Your Honor.
All right. So 4P will be admitted subject to testimony. What else? What was the fire marshal's report?
Fire marshal was 4Q.
All right. 4Q will be excluded for lack of authentication and subject to the previous exhibits or objections that were made. All right. Will that take us through all the exhibits?
Other than the expert reports?
Part of the police report that was testified to.
We're offering it. As the law.
I was gonna say, if you want to put a label on it, but I'm not going to admit the police report.
We won't offer it. Your Honor, I believe that's it.
What about the weather report?
That's in a Z.
Oh, it's in the Z, right?
All right, so you are going to review the court's proposed redactions to the expert reports of White, White 1, White 2, Hirsch, and let me know what your, I don't think that I had any edits to the Bassman report, but I don't know yet. I don't think we were ready to talk about that one yet. Okay? All right, so when we say move your exhibits into evidence, we will be ahead of the curve on that one.
Your Honor, the Hilltop records, what letter are they?
I have Hilltop as being Y, 33 pages.
Okay. Thank you.
And then what we'll do is after court today, we, once again, Ms. Kilgore will have her notes together by then and go through all of the exhibits to make sure that the exhibits are in the right order and that no exhibits are not there that shouldn't be or are there that should be, not there that should be.
Okay.
Okay? All right, is there anything else we need to talk about while we are sort of on the record?
Judge, would it be appropriate for us to black out, or redact, I should say, the table of contents for our exhibits, so we can keep that with?
I mean, I don't have objection to either side submitting an exhibit list. I think it's a good idea that the jury should have one. Just, I mean, it needs to be a redacted one, not just like, I mean,
Okay.
it needs to be either white lined or something so that the excluded exhibits do not, you cannot make them out from that. I assume that the state wants that as well? So
Yes, Your
you'll-
Honor.
All right, so we'll be ready with that tomorrow morning, and just give me that if you want to email it to me overnight.
Judge, it's, you cannot read that. This is a clean copy. Is that from?
Okay, if you give me if you give me the better copy, we will white it out once we get the exact edits. Because, yeah, that's a scanned copy of a photo from my Surface, so.
Should I give it to you now or give it to Mr. Mullins?
We can wait until we talk about it. Just keep it ready, at the ready. I'll take it. But this is just one of the reports, though, right?
It's just one, just because I can't barely read.
All right, so you can get me another of White's supplement and Hirsch and Bassman, you can get copies of all of those for me?
I can give you,
Okay, we can work on that on the break.
okay, thank you.
All right, anything else to talk about while we're on the record, Mr. Knippen? Ms. Crafts?
No, Your Honor.
All right, so we're gonna go off the record, you're gonna test the equipment, right, Mr. Mullins? And we're gonna make sure that our witness will be able to operate it from, I think that cord goes from there to there. So, all right, we're in recess.